Three estimates came back low. Only one was actually wrong. NAPAICC Insider Research Desk, Tampa Bay, Florida. A wind claim, a two-estimate dispute, and a re-inspected total loss each produced an insurance estimate that looked far too low, but a case-by-case review finds only one of the three represented an actual underpayment. The findings illustrate why a low number by itself tells you almost nothing, and why the same complaint can point to three unrelated causes. Key takeaways. 1. A low estimate is not by itself evidence of underpayment. Some estimates are simply unfinished, accurate to what had been inspected, and nothing more. 2. The most common source of a large dollar gap is not dishonesty. It is two estimates pricing two different jobs and being compared as if they were the same one. 3. A true underpayment is rare, and it traces back to specific, identifiable evidence, missing inspections, wrong measurements, ignored coverage, not simply a difference of opinion. 4. In all three cases reviewed, the correct response depended entirely on which of these three conditions was actually present. Claim 1, the wind claim, an unfinished file. Loss type, wind, roof, and siding. Adjuster estimate, $18,000. Contractor estimate, $95,000. Outcome, not underpaid. A homeowner's roof, siding, and interior sustained wind damage. The adjuster's estimate came in at $18,000. Her contractor, reviewing the same damage, returned a figure more than 5 times higher, $95,000. Online, the reaction was immediate and unanimous. Lowball, bad faith, a familiar story. I assumed the number was final. I had no way of knowing it wasn't. A homeowner in a comparable wind claim. The evidence told a different story. The adjuster had not been able to access the attic at the time of inspection. The kitchen cabinets had not yet been removed, leaving damage behind them unknown. There had been no destructive testing, no moisture mapping, and no engineer had been engaged. The $18,000 figure wasn't wrong. It was a snapshot of what could be seen on the day of a walkthrough, not a final scope of repair. Diagnosis, not an underpayment. An unfinished file, accurate to an incomplete inspection. Once the missing inspections were identified and completed, attic access, cabinet removal, and engineer's review, the estimate was revised to reflect the full scope of the loss. The lesson, never confuse an initial estimate with a final one. Claim 2, the two estimates, same house, different job. Loss type, general property damage. Carrier estimate, $42,000. Contractor estimate, $118,000. Outcome, scope disagreement, not necessarily underpayment. A second homeowner's carrier estimate came in at $42,000. His contractor's estimate, $118,000. Same house, same damage, nearly an $80,000 gap. His first assumption was that one side was lying to the other. A side-by-side comparison found the real explanation. The carrier's estimate was a bare repair figure. The contractor's estimate bundled in code upgrade costs, permitting fees, overhead, and profit, the labor to move and protect contents during the work, temporary structural protection, debris removal, and finish work down to paint and cabinetry. Same house, different job. Diagnosis, a scope disagreement, not necessarily an underpayment. Reconciling the two estimates line by line, rather than comparing the two totals, resolve the apparent gap within days. The lesson, compare scopes before you compare dollars. Claim 3, the reinspection, when the number really was wrong. Loss type, total loss, reinspected. Carrier estimate, $11,600. Independent estimate, $96,000. Outcome, true underpayment. A third homeowner's carrier estimate came in at $11,600. An independent estimate, ordered after she pushed back, returned $96,000. The gap wasn't a disagreement. It was a record of what had never been looked at. Case summary, Claim Autopsy research notes. A reinspection found missing roof elevations, no interior moisture inspection at all, no assessment of insulation or electrical systems. and an entire detached structure omitted from the estimate completely. The roof measurements themselves were incorrect. The waste factor used in the calculation was incorrect. Ordinance and law coverage, the added cost of bringing a repair up to current code, had been ignored entirely. At this point, the diagnosis was no longer a matter of opinion. Diagnosis: true underpayment, missing inspections, wrong measurements, and ignored coverage. The file was reopened and paid correctly following a full documented reinspection. The lesson: when the gap is built on missing evidence rather than differing judgment, it isn't a disagreement, it's an error, and it's correctable. Analysis: 3 homeowners, 3 different causes. 3 homeowners looked at 3 low estimates and reached the same conclusion. All 3 were wrong, not because their concerns weren't valid, but because they diagnosed the symptom before they understood the cause. Applying the wrong response in any of the 3 would have produced a worse outcome. Disputing a number that was never meant to be final, alleging bad faith over a simple scope mismatch, or accepting a figure built on missing evidence as though it were a considered judgment. The trap isn't receiving a low estimate. The trap is treating every low estimate as the same disease. Some estimates are incomplete. Some are measuring an entirely different job than the one being pictured. And some are simply wrong. Until that distinction is made, it is impossible to know whether the correct response is patience, documentation, or advocacy. Clinical Pearl: a low estimate is a symptom. Never mistake it for a diagnosis. Editorial note: homeowner names, adjusters, carriers, and claim specifics in this report are composite and fictional, constructed for illustrative and educational purposes. They do not describe any actual individual, insurer, or pending matter. This report does not constitute legal or insurance advice.